Hello? Okay. I don't know. Something is going on weird with my mic, and the cord keeps getting bumped, and then it's like not. Anyway, sorry. Hi. Hello. Welcome to Crime in Court. My name is Heather, and this is a rewatch of Karen Reed's hearing that took place today, this afternoon in Dedham Court, I think they'll say in here. And it's not live, so I just want to let you know, even though I'm live, but this happened earlier today, just so you're aware. So let us begin. I don't even know what this hearing is supposed to be about. They have so many motions still open, and they are trying to disqualify the district attorney's office, so maybe we'll hear something about that. I have not seen this. I don't know what's happening, so this is the first time I'm learning. I'm learning with you guys, so let's begin.
All rise for the board, please.
Oops, sorry.
Good afternoon, Your Honor. We are on the record on Commonwealth vs. Karen Reed on docket 22 CR 117. Beginning with the ADA, can we have the parties state their appearances, please?
Adam Lally for the Commonwealth. Good afternoon, Your
Good afternoon, Mr. Lally.
Good afternoon, Your Honor. Laura McLaughlin for the Commonwealth.
Good afternoon, Ms. McLaughlin.
Good afternoon, Your Honor. David Yannetti for Karen Reed. With me is my sister, Attorney Tanis Yannetti.
Good afternoon, Mr. Yannetti. Good afternoon, Ms. Yannetti. Good afternoon, Ms. Reed. Okay, we ready to start? All right. So what I'd like to do, the order I'd like to go in is, first of all, the Rule 17 motion regarding Trooper Proctor. So we did receive, and it was docketed today, an appearance of Attorney Michael DiStefano. And in his response to the defendant's motion, he tells us that Michael Proctor does not object to the defendant's motion for an order pursuant to Rule 17, seeking records from the Mass State Police Internal Affairs Division. So he doesn't object to that, so that motion's allowed. Any comment, Mr. Lally?
No, Your Honor, I would just say that the Commonwealth also does not object. Spoken to legal counsel from State Police, they do not object. Whatever limited materials are available at this time have already been provided to counsel for both sides with the recognition of an ongoing obligation to provide materials as they exist. So no objection to that being allowed without objection.
All right, so that's one done. The second motion that I'd like to start with is the defendant's motion for Rule 17 directed to Kevin Albert, Brian Higgins, and Brian Albert. Before we begin on this, Mr. Lally, is the Commonwealth opposed to either of the other two motions? Just a yes or no?
Yes.
Okay, and do we have third-party counsel here on either of these objecting?
Yes, I believe so.
Okay. All right, so I'll hear from you then, Mr. Yannetti, on your Rule 17 motion, seeking records from April 23rd to the present.
Thank you, Your Honor. With regard to this motion, Your Honor, Brian Albert was served with a subpoena to testify before a federal grand jury, and he begins reaching out for Brian Higgins. Brian Higgins testified to the federal grand jury that he stopped taking Brian Albert's calls. He stopped replying to Brian Albert's text messages. It's fair to say that led to a panic in the Albert family. We learned that Brian Albert contacted his brother, Canton Police Officer Kevin Albert, to intervene.
I'm actually going to stop you there for 1 second. Mr. Lally, is Kevin Albert a Commonwealth witness?
No, Your Honor.
Okay, I just wanted to clarify that.
Now, bear in mind, Your Honor, that the Canton police were supposedly conflicted out of this case at that point.
So I want to know where that is in the record before me, because I think you know, as Massachusetts counsel, that the state police have jurisdiction over homicides, correct?
Oh, they do, yes.
So where is it in the record that they were conflicted out?
Those are in reports that the prosecution provided to us. Mr. Lally also told me that orally early on in.
Okay, so I need those reports. I need that reference.
Okay, we're happy to provide that.
Okay, so I'd like it by tomorrow morning.
That's fine, Your Honor.
Okay.
So the Canton police had a conflict precisely because Kevin Albert is an officer in their department. So how can they conduct an investigation which includes the brother of one of their officers? It stands to reason they can't. They appear to recognize that. Yet Chief Berkowitz is talking to witnesses in this case, and Kevin Albert himself inserted himself into this case. Brian Albert testified to the federal grand jury about the fact that after Brian Albert received a federal grand jury subpoena, Kevin Albert contacted Brian Higgins. Kevin Albert said to Higgins, and I quote, "Look, you went off the grid, and Brian doesn't understand. You haven't called him, you haven't checked in on him since these subpoenas go out. Everyone got a subpoena but you." Those were Kevin Albert's words to Brian Higgins. And, Your Honor, there's only one way to interpret that. Brian Albert was panicked that Brian Higgins had flipped on him. Brian Albert enlists his Canton police officer brother to contact Higgins to try and find out if that was the case. Testified before the federal grand jury on June 1st of 2023. Higgins and Kevin Albert talked on the phone for a good 15 minutes. That was 2 days before he testified before the federal grand jury. Before he testifies to the feds, Brian Higgins is conferring with Kevin Albert, who supposedly conflicted out of the case. So, my goodness, with all the allegations of witness intimidation thrown around by this DA's office and special prosecutors they appoint, why has Kevin Albert never been investigated for witness intimidation? And for that matter, why has Brian Albert never been investigated? But as you ponder those questions, please realize, Your Honor, we're not asking for much here. We're only asking for relevant phone records. We're asking for contact between Kevin Albert and Higgins and Brian Albert. We're asking for contact that violates the self-recusal of the Canton Police Department from this investigation. Contact which impeaches them, contact which is relevant to their motives in this case. It impeaches the investigation. We are entitled to explore whether this investigation was conducted correctly and ethically. And we're entitled to explore whether improper influence was put upon witnesses by the Alberts. Without this testimony, this federal testimony from Higgins, and without the federal investigation, we never would have known of Kevin Albert's involvement here. But now we do. And the Commonwealth does. Why aren't they curious about what was said and why?
I don't know what that noise is. It's coming from there. So that background noise is coming from them, just FYI. It's coming from the room that they're in.
They've announced an objection to this motion. Why are they fighting our quest to get exculpatory evidence? We need this evidence, these phone records, in admissible form. That's why we're filing this Rule 17 motion. We have more than met the requirements of Lampron. The records are relevant because they tend to show a cover-up. They are relevant because they show a Canton police officer inserting himself into a case in which his department was conflicted out precisely because he was an officer there. They're relevant because they impeach the credibility of Commonwealth witnesses who deny that they are a part of a conspiracy, yet the phone records tend to show they were conspiring together. We cannot get these records any other way. We cannot effectively prepare for trial without these witnesses.
So you testified as to their relevancy. How are they evidentiary?
They're evidentiary because they are both relevant and material, and if they're provided by the providers with an appropriate affidavit from the keeper of records, they're admissible. The Commonwealth could have gotten these records at any point, but they chose not to. And they have fought our efforts to get all.
I don't know. This is why I don't like lives. I keep hearing this in the background of this video, and like do you guys hear that? There's like another person talking, like another trial's happening or something. It's frustrating me.
Thank goodness another law enforcement agency stepped in and did the job that the DA's office should have done but did not. We need these records. Going to trial without them would violate my client's rights to exculpatory evidence. It would violate her due process rights. And finally, to the extent that this court previously ruled that our requests for phone records were a fishing expedition, nobody can claim that anymore with a straight face. We now have testimony that these records exist, that calls exist, that text messages exist. As Mr. Lally said in the last hearing, phones do not lie. These phone records do not lie. We need them, and we ask the court to order them.
All right, it looks like you're asking the parties themselves to bring these in, though.
To the extent that they have them, that's accurate, Your Honor. We're also asking for their phone providers to
So
provide them as well.
they're two separately filed motions, right? And
Yes.
one of them is with Mr. Berkowitz, or former Chief Berkowitz, but he's not on the other. So I saw them as two distinct motions, and the one that we just heard you on, is really asking them to deliver whatever records, right?
Correct. I would note that the providers are on the second motion, except
But
for...
that's three different people or one different person on this?
One different person. So we have Higgins and we have Brian Albert on the first motion. We have Higgins and we have Brian Albert on the second motion. The difference is Berkowitz versus Kevin Albert.
Right.
Right.
Every time I pause it, the talking stops. So it's happening in their courtroom or around them. Anyways, so they want the phone records of Kevin Albert, who is the brother of Brian Albert, the homeowner of where Officer John O'Keefe was found with his life ended. And so Kevin is a Canton police officer. Brian is a Boston police officer, but because it's Brian's home, the Canton police, but Brian lives in Canton, FYI. So the Canton police had to basically recuse themselves from the case, but that didn't stop them from conducting the first search. So I don't know. And then the state police came in and took over after John was pronounced deceased at the hospital. So I don't know. Canton had control over the case for a brief period before the state police came in. So anyways, they had to take the Canton police off of it because of brother Kevin Albert. So that's what they're talking about. They want Kevin Albert's phone. And because they now know that Kevin Albert was talking to Brian Higgins, who was in the house, the ATF agent. He's the one that they think flipped to the feds. And that's what they were just talking about here. And then also Chief Berkowitz, who just recently retired, not that long ago. Chief Berkowitz was also the one who found one last little piece of tail light that was days later after the storm, and he just happened to find it driving by in a road that's not like a through road or anything, and he just happened to drive past Brian Albert's house one more time and looks out the window and sees a piece of tail light. So for some reason, Berkowitz got inserted into the case again, like because of this piece. Either he inserted himself or somebody in the police department inserted him into the case. I don't know what way it went, but somehow he became part of it by finding that tail light, several days later. Anyways, so that's what they want, are all three phone records of all of those individuals: the ATF agent, the brother of Brian Albert, and the chief of police, the Canton chief of police, who's now retired.
Okay. All right. Mr. Lally, I'll hear from you, and then I do see Mr. Henning here. I don't know if he wants to speak or not, but I'm going to hear from Mr. Lally now.
Well, it's been a very long road, but we have a bipartisan.
Your Honor, just very briefly with regard to this motion. With regard to the Rule 17 motion with request to records or communications from individual cell phones from April 1st of 2023 to the present day, firstly, the Commonwealth would just indicate the facts as recited in the defendant's motion the Commonwealth would submit are largely inaccurate. It's injected with hyperbole, injected with conjecture, in regard to federal grand jury materials which belie much of what counsel claims that they say. Essentially unsubstantiated conjecture which is directly contradicted by the testimony and the evidence contained within the federal materials. Now, I know that the court has had those materials and has carefully reviewed those materials, so I don't feel the need to go into each and every specific ground. However, what I would say, secondly, even assuming that everything contained within counsel's motion was true and accurate, the defendant's motion in this specific instance fails on two grounds. Number one, what the Commonwealth would submit is that the time period that's being requested is far too overbroad for whatever collusion or whatever purportedly occurred, according to counsel, going from almost a year worth of communications from people who, admittedly, through the testimony, through the evidence that was presented and has been presented in both forms, knew each other well and knew each other well before any of this occurred and continue to associate and be friends following this incident. Secondly, the sort of last paragraph of counsel's motion claims that the records are needed to establish the exact nature and extent. What the Commonwealth would submit is really what they are needed for, from counsel's perspective, is to establish the existence of these conversations and what the content of them were, which is the very epitome of a fishing expedition. And so for those two reasons, the Commonwealth would submit that the defendant has not met the standard under Lampron, and that motion should be denied.
All right, so I see Mr. Henning, so I don't know, do you want to be heard? Yeah, please come forward. And I don't know who counsel is for Mr. Higgins, but if he or she's here, do you want to be heard as well, sir? Great, so I'll hear you after I hear from Mr. Henning.
Good afternoon, Your Honor.
Good afternoon.
On behalf of Brian Albert, I just wanted to put three things on the record for the court. The first is, and I'm sure the court is aware, that the parties that are the subject of the Rule 17 motion have not actually received the motions. We got the cover page, we got the orders and the proposed orders, but we have not been able to review the actual memoranda because, at least according to the interpretation of the protective order, we're not entitled to see that content. And that...
All right. I ruled that they were to be given because the federal proceeding is not to interfere with this court's proceedings.
I understand that, Your Honor, and I did receive the court's order, and I informed each of the respective counsel that I spoke to as far as what the court's order was. And I also understand that the court hasn't had the opportunity to review the federal protective order, but my interpretation of that order simply would not permit dissemination of the material contained within the memorandum.
Even though the Lampron Protocol says shall, doesn't that supersede a federal protective order? It's the law of the SJC. How can third-party record holders, the people who Rule 17 in the case law protects, not be able to go forward without it?
And I understand there's a direct contradiction there, and so out of an abundance of caution...
Okay, no, I understand you're following your order. I'm going to make it available. Not a party to any protective order. So we can take a recess. You can have them now. What do you all want to do? I mean, I didn't know that the Commonwealth was not complying with my order. I understand why you didn't, but I didn't know that.
My apologies.
I'm happy to be heard now, and if the court will allow us to review the motion and the memoranda, we can amend with a written filing if there's something we need.
Yes, pursuant to a protective order, the way we have them in the Massachusetts courts for Lampron Dwyer records.
Okay.
So,
Can I have one moment, Your Honor?
yes.
Your Honor, what I think the counsel for the third parties would ask is that we are able to address the court today, but allow us an opportunity to review the memoranda and submit something in writing before the court makes an order.
Sure. I'm just rereading the appendix on Dwyer, and it is a shall. So my view is that the SJC in Commonwealth versus Dwyer, the procedure that we're to follow, allows certainly, and I say mandates, that the third-party record holders be given this information. So we will provide it when we take a recess today. I'll ask Mr. Clerk to make copies of what I have, not what the lawyers have. We need protective orders signed before you're given them. And I will have them given to all three record holders, or four if there's somebody here from Mr. Berkowitz. All right, I'll hear you.
Thank you. The first part of what I wanted to address is dovetails with what Your Honor is just addressing. The fact that we are third parties in this matter and do not have access to the materials that are in the subject of the discussion from the federal side of things makes us at a disadvantage here in front of the court. Obviously, we're going to remedy that, hopefully, by being able to review it. But that notwithstanding, the fact that there is materials that we can't review that are being discussed in front of the court, even if we are able to see the memoranda, makes it difficult to address these. And I think for an issue of fairness, I want to make sure that the record's clear. If there are future motions, I want to preserve and not waive any argument as to the fairness of being able to access those records. So that would be the first point. The second point is, going into this, not having an opportunity to review the record, I do believe that the Rule 17 standard of relevance still needs to be met regardless of whether we get to see the material or not. So what I do want to offer to the court to consider as part of your determination here is that after receiving the notice from the Commonwealth last week, I contacted the U.S. Attorney's Office and I spoke to the lead prosecutor in the case.
Okay.
What I want to have the court know is that I have permission to notify the court that Brian Albert, his wife Nicole, his son Brian Jr., and Caitlin are not targets of the federal investigation. And I've been given permission to disclose that in open court.
Okay.
So I think it's important for the court to know that as you go into the motion that you're considering and the arguments from the defense. The third thing I would like to just ask the court is, notwithstanding everything that's just been said and reserving the right to file that written document later on, Brian Albert does not object to turning over the materials that are being requested. I understand that the Commonwealth may be having objections as to the Commonwealth's case, but Brian Albert does not have anything to hide. He does not have anything that he needs to to prevent the court from seeing this material. And if the court does deem, after reviewing the material and having access to the federal records, that these are somehow relevant or that these are somehow admissible, and the court deems that Rule 17 has been satisfied, Brian Albert will comply with the court order.
Thank you very much.
Thank you. On behalf of Kevin Albert, present is Peter Pasciuco, and on behalf of Brian Higgins is William Connolly.
Great. Thank you. All right, so counsel, I need you to spell your name for me, please.
Yes, Your Honor. The last name is Connolly, Connolly.
And what's your first name?
William.
Thank you. All right, I will hear you on behalf of Mr. Higgins.
Thank you, Your Honor. Your Honor, as the court is aware, Brian Higgins' phone records and communications are at issue in these motions. Brian Higgins is a federal ATF agent. He is a witness in the Commonwealth's prosecution of this case, and he has cooperated fully in the Commonwealth's investigation. As this court knows, we've not had the benefit of seeing the factual support for these motions, but I want to provide some information that likely isn't contained within those materials submitted to the court, but of which I have a good faith basis to believe is information contained in the materials provided by the federal government to the parties in this case. I have represented Brian Higgins since April of 2023, the month when he received the federal grand jury subpoena. Like he has in this case, Brian has cooperated fully with the federal investigation. He has answered every question put to him in both investigations, and he will continue to do so because he has nothing to hide. Brian Higgins is not a target of the federal investigation. That has been confirmed by the United States Attorney's Office and confirmed to me that I could make that representation in court. The U.S. Attorney's Office has continuously confirmed throughout its investigation that Brian Higgins is not a target of their investigation. Brian Higgins has not participated in any kind of a cover-up or conspiracy to cover up the criminal activity of others. Brian has spent his career saving lives. He was a firefighter before becoming an ATF agent. He has been an EMT since 1992. He received a congressional medal for saving the life of a fellow ATF task force officer after being shot 5 times in Somerville, Massachusetts. He has served our military in Iraq. Participating in a cover-up is contrary to who he is as a human being and a professional. I am here to represent Brian's interest in privacy. Brian Higgins, at my urging, will not capitulate and stand down when efforts are made to further intrude upon his privacy based upon sheer speculation. It is for that reason that we oppose these motions, not because Brian Higgins has done something wrong or has anything to hide. We know this court will give us an opportunity to review the motions and supplement our remarks if we deem it necessary. We know this court will fairly weigh the arguments before it and will render a fair decision, and we will respect that decision and we will comply with that decision. Respectfully, we do not believe there is a sufficient factual basis to support the relief requested in the motions before the court. Thank you, Your Honor.
All right, thank you very much.
Judge Cannoni breathes in her mic a lot. That's always her, like, sighing really heavily into the mic, just so you know, it's not me. That was my dog. She's walking around shaking her head.
Counsel?
So now this is Chief Berkowitz.
Good afternoon, Your Honor. Attorney
I
Peter
think.
Pasciuco on behalf of Kevin Albert.
All right, so you need to spell that last name
Or it's
for us.
P-A-S-C-I-U.
Oh, he's the attorney on behalf of Kevin Albert. So we just heard Brian Albert and Brian Higgins, and now this is Kevin Albert's attorney.
CCO.
Good afternoon.
Yeah. Thank you, Your Honor. Just a little bit of background with respect to Mr. Albert, and we are objecting to this Rule 17 motion. Kevin Albert's a 19-and-a-half-year veteran of the Canton Police Department, extremely well-respected, extremely well-liked. Any insinuation that he participated in a conspiracy or a cover-up is simply untrue. There's been no showing how personal communications between my client and Mr. Higgins have any relevance here, let alone evidentiary value. Kevin Albert is not a Commonwealth witness. He did not testify in the federal grand jury, and his involvement is essentially zero. This is a clear intrusion, as Attorney Connolly indicated, into the privacy rights of these individuals, and I've advised Kevin that there is simply no reason to acquiesce to something that's just clearly a fishing expedition. So upon my advice, Kevin Albert is objecting to this Rule 17 motion, but we will honor and respect the court's decision and appreciate the time to supplement any response in writing after we see the motion and affidavit, which hasn't been provided to us yet.
Okay, thank you very much. All right, Mr. Unetti, did you want to respond or no?
No, I would just move to the next motion if the court were ready.
Okay, so we'll move on to the next motion. Mr. Lally, you didn't want to add anything, did you?
No, thank you, Your Honor.
Okay. All right, so this motion concerns Brian Albert, Kenneth Berkowitz, Brian Higgins.
Yes, and Your Honor, with the court's permission, I'd like to start with Brian Higgins with regard to this motion.
All right, so Mr. Lally, is it safe to assume you did not provide, or you didn't comply with my order in providing the motions and supporting affidavits on this as well to the third-party record holders and their lawyers?
Yes, Your Honor.
Okay. So the council will receive copies of this as well and be permitted to argue now and supplement it. All right.
Thank you, Your Honor. As I previously mentioned, Brian Higgins did testify before the federal grand jury, and at that time he was specifically asked if on January 29th of 2022 he made any phone calls when he got home. He said that he did not. He testified that he lived alone. He testified that he was alone that night. He testified there was nobody else in his bedroom. He testified that when he went to bed, he placed his phone on the bedside table. After making those admissions, he was confronted by a federal prosecutor with his phone records. Those records revealed that Brian Albert called Brian Higgins at 2:22 in the morning on January 29. Those records reveal, moreover, that 17 seconds later, Brian Higgins called Brian Albert back, and that call lasted for 22 seconds. Now, when he was first confronted, Brian Higgins first tried to claim that it had to have been a butt dial. That term butt dial is used by many of the Commonwealth's witnesses to explain the many calls between them and among them, and I've never seen a case where there have been so many butt dials, to be frank. But Mr. Higgins was already locked in. He already testified his phone was on the bedside table. His butt was in the bed, the phone was in the table. The two could not have met, Your Honor. There was no possibility of a butt dial. And then Higgins admitted that. And that wasn't Mr. Higgins leaving Brian Albert a voicemail. He also admitted under oath that the toll records would have reflected a voicemail if they went to voicemail. He admitted that to call Brian Albert back, he would have had to first reach for his phone, then unlock it with the passcode or Face ID. Then he would have to press on Brian Albert's number. And that is exactly what he did. And he testified that that was what he did. He also testified that nobody from the Commonwealth, not Trooper Proctor, not ADA Lally, no one has ever asked him about that phone call from Brian Albert to Higgins, or the return phone call from Higgins to Albert lasting 22 seconds. Rather than get everyone's phone records, as this court knows, the Commonwealth has fought the defense at every turn in our quest to get the phone records. They've persuaded this court that we were previously on a fishing expedition. To the extent the court once thought otherwise, it is clear this is no longer a fishing expedition. We do not have to go fishing to wonder anymore whether calls were made. We now know that someone who had been in that house when John O'Keefe arrived called the homeowner at 2:22 in the morning, 3.5 hours before John O'Keefe's body was found on the homeowner's lawn. We learned that neither party to that call ever revealed to police, investigators, or prosecutors that they connected by phone in those early morning hours. Just like Jennifer McCabe never revealed that at around the same time she was Googling, asking how long it took for someone to die in the cold, a search that the FBI confirms happened at 2:27 in the morning, again, about 3.5 hours before John O'Keefe's body was found. Now, for his part, Brian Albert also first tried to claim that his phone call to Brian Higgins at 2:22 in the morning was a butt dial. He said that he was awake and watching TV, but he was called back to the grand jury to testify a second time. The second time, Brian Albert changed his testimony to say that at 2:22 in the morning, he and his wife were in bed in an intimate situation. He claimed that he had his phone with him in the bed. So now he's claiming that it was during that intimate situation with his wife that he supposedly butt-dialed Brian Higgins. He had no explanation, however, for how his phone picked up when Higgins called him back 17 seconds later. He had no explanation for the 22-second phone conversation that followed, and it's worth noting that Higgins testified he never heard any intimate noises on the other end of the line either. Brian Albert tried to maintain that he butt-dialed Higgins, but again, that would mean that his butt also answered the phone when Higgins called back, and it doesn't make any sense. Both men denied talking to each other despite being confronted with that mountain of evidence by federal prosecutors. But it wasn't just the January 29th, 2022 calls between Higgins and Albert. Brian Higgins' phone records, we learned, reveal that Canton Police Chief Kenneth Berkowitz was involved in interacting with both men shortly after John O'Keefe's body was found. And again, recall, they're supposedly conflicted out of this case.
So I'm going to, there's just a question I have, and I'll let you continue, Mr. Yannetti, but regarding the dates. So the dates of the records you're seeking for Brian Albert, so January 29th to February 4th.
4th or 5th, yes.
4th. That's what you're
That's
seeking.
fine. That's fine.
And for Kenneth Berkowitz, January 29th to February 18th, and Brian Higgins, January 29th to February 18th. I need you to explain to me why those dates, why
Right, so-
February 4th and February 18th.
There was testimony in the federal grand jury that Berkowitz and Higgins were speaking to each other up through the 18th. With regard to Mr. Albert, we had evidence through the 5th.
All right, it's not entirely clear from the affidavit. Okay. All right, so go ahead. Thank you for answering that, and I'll hear you. Go ahead, continue.
Right. So as soon as John O'Keefe showed up deceased on Brian Albert's lawn, Canton Police decided it might not be a good idea for them to be involved in investigating this case. And by the way, I'm reminded when I sat down that District Attorney Morrissey announced that publicly. So we knew that early on.
Okay, so is that in his statement that I've had copies of?
It is not in the video statement that we moved to sanction him for. It was a previous statement that he issued.
All right, so get that to me, okay?
That's fine, Your Honor. So the question is, why was Chief Berkowitz inserting himself into this case almost immediately? United States Attorney Joshua Levy questioned Higgins about that in the federal grand jury. He summarized the phone records in their possession, records the feds have that we do not, records we're asking this court to order so that both parties in this case can review them. Mr. Levy directed a question to Mr. Higgins in the grand jury where he asked about all of the back and forth between him and Brian Albert and Chief Berkowitz. Quote, you have a 3-minute call with Berkowitz at 7:22 in the morning. This is on January 29th. Another call with him then you have a call with Brian Albert that afternoon for 12 minutes. Another call with him for 6 minutes. Another call for a minute. Then another call with Albert for 10 minutes. Then a call with Berkowitz for 4 minutes. Higgins spoke with Berkowitz on January 29th, someone who was conflicted out of the investigation 4 times. And then they spoke many additional times between January 29th and February 4.
But Higgins had nothing to do with the investigation, correct?
He was a witness in the investigation.
Okay, at that point,
We have a chief of police who's supposedly...
I'm sorry, I just need to, so at that point you say he was a witness?
I'm sorry?
At that point, the point of the phone calls, he was a witness?
Yes, he was in the home, Your Honor.
Okay.
He was not spoken to by investigators yet, but clearly he's a witness. He was at the home that night. Now, recall that Chief Berkowitz supposedly found a piece of taillight on Brian Albert's lawn on February 4th. After that lawn had been searched by trained investigators and other police officers multiple times without finding it, but somehow Chief Berkowitz was able to spot that piece of taillight while he was driving past the property from his moving vehicle. And the phone records show that Berkowitz called Higgins that very day to tell him about the discovery, and then Higgins calls Brian Albert to tell him. In a case where we are alleging as part of our defense that there is a third-party culprit, and at least some people are involved in a conspiracy to cover up the guilt of that third-party culprit or culprits, contact between co-conspirators could not be more relevant. Before the feds got involved, we fought for this information, but we were largely unsuccessful. Although we never had to prove that the phone records actually contained evidence of the conspiracy. That's something we couldn't do without having the records themselves. This court has previously ruled that it was all too speculative. Not anymore. Not now. Not after we know that the records exist. Not after we know they prove what we suspected that they would prove. We now know that those records will tell a story that could not be more relevant to this case and to our defense. And the problem, Your Honor, is we know the records are there. We have them in summary fashion, but we don't have them in admissible form. The feds have revealed that they exist, but they haven't released the actual records to us. They have them, we don't have them. That's why we're filing this Rule 17 motion. And again, we've more than met the requirements of Lampron. These records are relevant to our defense because they show suspicious contact between parties we allege to be in a conspiracy. They're relevant because they show the Canton police chief inserting himself into a case when it was previously determined that he was conflicted out. They are relevant because they impeach the credibility of Commonwealth witnesses who denied talking to each other, yet have no explanation for these records, which again, do not lie. We cannot get the records any other way. We cannot effectively prepare for trial without these records. The Commonwealth could have gotten them, but they chose not to. They fought our efforts to get them. But again, thank God, another law enforcement agency stepped in and did what the DA should have done. Going to trial without these records would violate my client's due process rights. And finally, to the extent that this court previously ruled that our requests were a fishing expedition, we can't maintain that now with a straight face. We now have the receipts. It's confirmed we were never on a fishing expedition. We were merely on an expedition to obtain relevant material and exculpatory evidence, and we're simply on a mission to defend our client. And I would ask the court to allow this motion.
All right, thank you very much. Mr. Lally?
That was good, I thought.
So, Your Honor, the Commonwealth does not object to this motion. The only question or clarification that I'd ask for is there seems to be a discrepancy in the dates that I'm not really finding any support for within the context of the motion. So
So that's why I asked. So,
my question was a different one as to the dates, though. So
Okay.
when it directed towards individual people, it's a time period beginning on January 29th. When it's directed towards the cell phone carriers or providers, it begins with a period on January 28th, which is the day prior to anything occurring. So I'm not sure why anything on the 28th has any relevancy. There's nothing in the motion that I can glean that indicates that. I don't know if it's a Scrivener's error or if there's some other reason for that period for those providers to be starting a day early.
what do you say about that, Mr. Yannetti? Your affidavit says the 29th.
Right. I would orally amend that to the 29th, Your Honor. We're fine with that.
All right. I'm going to hear from the third-party counsel if they want to be heard.
Your Honor, if I may, just one further thing. I did speak with counsel. It's Attorney Kenneth Anderson, who represents Mr. Berkowitz. There's no objection on behalf of his client.
Okay, thank you.
No
All right, so Mr.
objection.
Conley?
Yes, thank you, Your Honor. Your Honor, with respect to our general arguments, we'll just rest on I'll rest on what I said previously, and we respect the parties' positions. I just want to point out one thing with respect to the factual assertion. I don't have the privilege of seeing the grand jury testimony, but I can represent to the court that before my client ever testified at the grand jury, he voluntarily appeared for an interview with the U.S. Attorney's Office. I attended that interview, and at that interview, he volunteered to the U.S. Attorney's Office that that morning he spoke to both Albert and Berkowitz. He was not asked and did not give a rundown of how many times, but he acknowledged long before he testified at the grand jury that he did speak with both of them that day. I don't think that impacts the substance of the arguments, but I just wanted to note that for the record.
Okay, so just so I'm clear, the Commonwealth hasn't objected to these records for that period of time that appears to be relevant time period.
And so I will waive argument on that, Your Honor.
All right, and does counsel object to these records? Mr. Henning on behalf of Brian Albert? All right, and counsel on behalf of, oh, that doesn't concern you, okay. All right, thank you. Defendant filed, Mr. Yannetti, you filed a motion that I just got as I was walking out here.
Right. We're not asking to be heard on that motion. I had alerted your clerk that it would be coming. It's filed with a motion to impound as well. I figured I would hand deliver it today.
Okay,
The
great.
Commonwealth just got it today, so they'll need time to assess that.
All right, so today, all pre-trial, non-evidentiary motions have to be filed pursuant to
Yes.
the order.
Yes.
All right, so this is it? This is
No,
what the...
I expect by the end of business today, the court will be receiving a motion to dismiss to be heard next week as well.
All right, and you can't be here next week?
I cannot, and on that point, Your Honor, I think the court probably was alerted that we filed a second motion to admit counsel from California, pro hoc vice. I don't know that it's necessary, but
I'm glad you filed it because I think it is. If you're not here and you have to be here
that's
for
why we
that,
did.
so...
That's why we did that. So,
Ms. Yannetti, I'll allow that motion now that you have filed your appearance.
thank you so much.
Okay. All right, so you expect that there will be more motions coming today?
I expect there'll be one additional motion coming today.
All right. Does the Commonwealth have anything that it expects to be filing by the end of today?
Your Honor, just filed a motion for reciprocal discovery. Not asking for any action on it, but I believe that would be it.
Okay, and I have one question. Are we all done with Bodie Labs? Have you received the information from them?
So on one part of the testing, yes.
Okay.
On the second piece of the testing, no.
All right, so I need a report on that orally on Tuesday.
Sure.
Where we are with that. All right, great. I'll see everyone Tuesday. Thank
Thank you,
you.
Your Honor. Thank
All
you.
right.
March 26th.
So that was the hearing today. It was basically to get the phone records of Brian Higgins, Brian Albert, and Kevin Albert, and also Chief Berkowitz. So 4 phone records for 4 individuals. And it looks like there were several no objections, so we might be getting some of those phone records, hopefully, and we can confirm whether they were talking or not, and if there was some kind of cover-up and conspiracy that they might have been talking about on their phones. But you would think law enforcement would be smart enough not to talk about a crime that they committed over their phones, their cell phones. But then again, John McCabe did Google how long did I called at 2:27, and these idiots called each other at 2:22 in the morning when we know everybody left the house around 1:30, 1:45. And they left the Albert house. So by 2:30, people were home and on their phones and antsy and calling people and Googling things. So that's what happened, in my opinion, because they knew they were nervous about what they just did. And they knew John was on the lawn. I don't know if Higgins knew, but I definitely feel like Albert knew. Both Alberts knew. I mean, had to have called brother Kevin over and said, hey, your nephew did something stupid or whatever, you know, if it was something that Colin did. Or if it was Brian Albert and Colin, we don't know. Could have ganged up on him. Anyways, there's many theories that could happen, but at least now we might be getting some cell phone records, which is great news because we can confirm if there was something going on behind the scenes. So thank you so much for watching, tuning in, replay crew, all of you, thank you again, and please don't forget to hit that like button, subscribe, and I will see you in the next one. Take care. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.